relevant to the current global situation. Conflict in different parts of the world continue to create complex humanitarian challenges affecting human security, fundamental rights, migrations, economic stability, and international relations. In this context, international law plays an essential role not only as a legal framework, but also as an instrument for protecting human dignity, promoting justice, resolving dispute, and maintaining international peace and security. Universities have an important responsibility in responding to these global challenges. Higher education must provide a space where scholars, students, practitioners, and international partners can exchange ideas, critically examine global issues, and develop solutions based on knowledge, justice, and humanity. For this reason, Universitas Pancasakti Tegal is currently continuing to expand and strengthen its international collaborations in all aspects of three pillars or three dharma of higher educations, teaching and learning program, research, community engagement. Internationalization for Universitas Pancasakti Tegal is not merely about signing agreements or establishing formal partnerships. More importantly, it is about transforming those partnerships into meaningful and sustainable academic activities. We therefore continue to encourage various forms of international cooperation, including student and lecturer mobility, visiting professors and guest lecturers, joint seminars and international conference, collaborative research and publications, joint community engagement programs, as well as other academic and cultural exchanges. Through these activities, we want our students and lecturers to gain broader global perspective while also creating opportunities for UPS or Universitas Pancasakti Tegal to contribute its knowledge and experience to the international academic community. Our collaboration with universities and institutions from different countries, including our partners in Poland and Turkey, reflect our commitment to building a stronger global academic network. We hope that today's seminar will not be an isolated activity, but will become another important step toward deeper and more productive collaboration in the future, particularly in the fields of law, education, research, and other areas of mutual interest. I would like to deliver my expressions and to the Faculty of Law of Universitas Pancasakti Tegal, and also the organizing committee, our international partners, distinguished speakers, and everyone who has contributed to making this seminar possible. Finally, I hope this seminar will provide valuable knowledge, inspire meaningful academic discussions, and strengthens friendship and collaborations among our institutions. By saying Bismillahirrahmanirrahim, I hereby declare the international seminar, Navigating International Law in Times of Conflict and Humanitarian Challenges, opened. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Professor Taufiqullah, for officially opening today's international seminar. So, ladies and gentlemen, with that, our international seminar on navigating international law in times of conflict and humanitarian challenges is officially open. Well, ladies and gentlemen, we have now come to the main sessions of today's program, and it is our great privilege to welcome three distinguished speakers representing universities and academic perspective from Turkey, Indonesia, and Poland. We sincerely appreciate all our distinguished speakers for joining us today and for sharing their valuable knowledge, expertise, and perspective with our academic community. Ladies and gentlemen, to guide us through the presentations and discussions, we are also pleased to have Dr. Yoga Prihatin, Dean of Faculty of Teacher Training and Education, Faculty Universitas Pancasakti Tegal, as the moderator of today's seminar. Without further ado, I'd like to hand over the session to our moderator, Dr. Yoga Prihatin. Please take it away.
Thank you so much for our Honorable Master of Ceremony, candidate candidate of Doctor Ibu Ihda Rosdiana for your excellent Master of Ceremony today. Ladies and gentlemen, it is an honor for me to be the moderator here today for the international seminar with the topic Navigating International Law in Times of Conflict and Humanitarian Challenges. And it is a great pleasure for me to invite our honorable first speaker from Turkey, Assistant Professor Dr. Mahmudul Hasan. Are you here? Hello, Professor, are you here?
Yes, please. Yes,
Okay.
please, I'm here. Thank you.
Oh, thank you so much for being here. But before before Assistant Professor Dr. Mahmudul Hasan present his presentations today, I would like to introduce you about him for a very short biography of Professor Assistant Professor Dr. Mahmudul Hasan. Operator, please help me. No, not this one. I need a short biography. Thank you so much. Ladies and gentlemen, here is a very short biography of Dr. ASM Mahmudul Hasan. He is an assistant professor of international law at Karabük University, Turkey, and a research fellow at Kapgem, I don't know how to pronounce this, with previous academic roles at Bursa Uldag University and the International Islamic University in Chittagong, while also serving as executive director of the Istanbul-based Center for Policy and Social Research, and maintaining an active legal practice as an advocate of the Bangladesh Supreme Court. He holds a PhD in international law from Bursa Uldag University, multiple master's degrees, and a gold medal for his LLB with research spanning international law, sea law, legal studies, international relations, Islamic law and theology, and human rights, reflected in his books, chapters, articles, and conference presentations. Thank you. Well, ladies and gentlemen, operator, please close. Thank you so much. Ladies and gentlemen, again, it is a great honor for the Faculty of Law of Universitas Pancasakti Tegal to invite the Honorable guest speaker or keynote speaker here, Assistant Professor Dr. Mahmud. Please do, you have about 15 minutes to present your presentation. Thank you.
Thank you very much.
You're welcome.
Yes.
By the way, Professor, before we start, would you like to? Okay, would you like to share? Okay, thank you, thank you.
Yes,
Yeah,
I am
please
sharing.
do. Yeah, please do.
So, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Good afternoon, Salamat Siang, distinguished colleagues, honorable scholars, researchers, and dear students. It is a great pleasure to privilege to be with you today. I am sincerely grateful to the organizers for the opportunity to speak at this important seminar. So as you can see here in my presentation, as it was before, the title of the seminar was International Law Amid Armed Conflict and the Global Humanitarian Crisis. Based on this main theme, I prepared my presentation. My title is here, When Law Meets War. So in this presentation, I would therefore like to focus on a simple but very important question. When law meets war, how can legal protection become real protection for civilians? As you know, there are several laws, but in practice, we can see the difference. So what will be the solution? So we try to make the framework for the solution within the 4 R's. R is a letter of English. We said here there are 4 R which can make a solution for the civilian protection. Number 1 R for rules, number 2 R for rulings, third one is for response, and fourth one is for redress. maybe in Indonesian language, rules aturan, rulings, putusan, response is response, and fourth one is redress for pemulihan. So we said here, we tried to focus here, and my central argument here is very simple. Civilian protection in any armed conflict becomes effective only when all four functions means here rules, rulings, response, and redress, all four functions work together rather than in isolation. That means perlindungan warga sipil hanya dapat berjalan secara efektif apabila keempat fungsi tersebut bekerja secara terpadu, bukan secara terpisah. So this is my very central argument here. So dear audience, you can see in this scenario in my presentation, it is a very unfortunate, a very sad scenario. It is a formal report published by the United Nations in last year. Within 1 year in 2025, the United Nations recorded more than 37,000 civilian deaths across 20 armed conflicts, approximately one recorded death every 14 minutes. But this report is just only formal report. Informally, the number is very big, because we said here the recorded number, you know, the word recorded matters because there are various restrictions, limitations for the United Nations to formally announce the number. However, it is not the full global toll. It is a simple scenario that in every 14 minutes, one person died in last year in only just 20 armed conflicts. So while this scenario is in front of us, we should search for the solution. The law itself is not enough. For example, we said, how does a hospital's legal protection become better target verification, a changed for a flight path, or a decision not to attack? What will be the solution? So for this reason, we try to make the solution within 4 hours. As you can see in my presentation here, number 1 R for rules, and number 2 rulings, number 3 redress, and number 3 response, and number 4 redress. So we said here, civil protection is continuous process before any armed conflict, during any armed conflict, and as well as after military operations. So before any action, it requires reliable information, risk assessment, and lawful choices. During action, circumstances must be reassessed and unlawful attacks suspended, because as you know, using force is totally prohibited by the United Nations Charter of the United Nations according to Article 2 of the UN Charter. But unfortunately, when we can see the practices of the world, we see Israel is attacking Palestine, Russia is attacking Ukraine. There are several debates regarding the legal justification, but always we saw, even before the International Court of Justice, Israel is justifying their attacks, justifying their use of force by saying that they are using the exceptional matter as self-defense, as well as Russia, because as you know, in law, in international law, all kind of intervention, all kind of use of force, all kind of armed conflict in general sense, it is totally prohibited. But there are some exceptional cases where intervention or use of force are legal. One of them is self-defense. Second one is humanitarian intervention and responsibility to protect. And as third one is intervention by the United Nations, intervention by the United Nations, Unite for Peace decision. There are some exceptional matters. But unfortunately, when we see the practices of the world, all the state party of the UN Charter, they are claiming that their use of force, their attacks are legal because of exceptional cases. However, so within this present current scenario, we said that the civil protection can be protected by this 4 R's framework. So here we said the rules establish duties and prohibitions as UN Charter and other international legal declarations. Rulings clarify state or individual responsibility. As a state member like Turkey, Indonesia, Poland, all are the state member of the United Nations. So the rulings will clarify the individual responsibility. Their response, that means number 3 R, gives law practical effect through cooperation, humanitarian action, arrests, evidence, and United Nations measures. And lastly, redress recognizes victims victims of the war. A big number of people, children from Palestine, from Gaza, they are victims. Repairs harm where possible and supports non-repetition. So these four frameworks functions form a chain and cycle. If one link fails, the protective force of the others become weaker. This is our claim here. So dear participants, as you can see here, four legal languages ask four different questions. In the international legal field, international legal arena, international humanitarian law is the not sole authority to apply to force the international law, specifically for the using of force by any state to other state. There are several actors, legal actors. So one of them is jus ad bellum. It is a Latin terminology. It is a universal principle of international law. So this principle asks whether a state may lawfully use force under the United Nations Charter or not. This question will be made or will be done by jus ad bellum. And second actor is international humanitarian law, or in other words, we can say international law of armed conflict, or in other words, we can say jus in bello. So this law regulates how hostilities are conducted once an armed conflict exists. It applies regardless of whose cause is considered just. And thirdly, international human rights law. This is also very, in the current modern globalized world, very applicable law. International human rights law continues to apply during conflict, although its relationship with humanitarian law depends on the right and context. And lastly, international criminal law. As you can know, you know already that international criminal justice, specifically in this field, in a big part belongs to the International Criminal Court, ICC. However, we said here international criminal law asks whether an individual committed a defined international crime like war crime with the required conduct, responsibility, and mental element. So before that means before going to the 4R framework, we try to identify here very shortly the problem and framework. The major and main problem, we can see the classification and civilian status, because sometimes as you know, there are several legal applications within the international humanitarian law for any kind of armed conflict or war. That means civilian always will be protected. But there are classification of international armed conflict. As you know all, there are two kind of international armed conflict. One is IAC, International Armed Conflict. That one is between two state, that means state party, state armed forces against other state armed forces. This is international armed conflict. On the other hand, another armed conflict is a non-international armed conflict. That means that one is not between two state forces of any state. That was maybe within two rebellion group or within a country. Like maybe we can give an example from Indonesia, Free Aceh Movement. It is a non-international armed conflict, not an international armed conflict. And beside this, occupation is another one. And lastly, the effects, not labels. So we have said here, international armed conflict exists when armed forces is used between states. Non-international armed conflict requires sufficiently intense violence and sufficiently organized parties. And occupation, on the other hand, exists when foreign hostile forces exercise effective control over territory without the territorial state's consent. That means without the consent of that state party. So this classification depends on facts, not labels such as security operation or counter-terrorism campaign. As you know, United States made several counter-terrorism campaigns saying just on labeling, but these are the international matter of fact of international armed conflict. However, within hostilities, civilians may not be targeted in any way. They lose protection from direct attack only for such time as they directly participate in hostilities. So living near fighters is not enough. Transmitting coordinates for an immediate attack may qualify. That means classification of civilian is very important. And after that, we said here, protection must see different risks. Very simply, our claim is here, international law protects every civilian, but conflict does not affect everyone in the same way. The example is in front of us in Gaza in Palestine. There is a law that means civilian will be protected, but no, conflict does not affect everyone in the same way. There are several classifications: men and boys, children, women and girls, older persons. So we said here, men and boys may face recruitment or arbitrary detention. Children may suffer abduction, family separation, and interrupted education. Women and girls may face sexual violence and barriers to essential health care. Older persons and persons with disabilities may be unable to receive warnings, evacuate safely, or reach humanitarian assistance. For example, an audio warning done by a state party may not reach a person with a hearing impairment, while an inaccessible route may prevent a wheelchair user from evacuating. So here we said that it is a question: why do armed actors obey law? For example, a state party like Israel or Russia or any other actors, armed forces, why they will follow the international law? We said here there are some options, because no single theory fully explains why armed actors obey international law, but criminal, diplomatic, and material consequences may deter violations. But punishment is not only one pathway. Here you can see, we said here, there are several examples. In summary, we can see the ICRC, International Committee of Red Cross, emphasize training, fear, expectations, identity, values, and organizational cultures. A clear command reinforced through realistic training may influence conduct more effectively than a legal lecture alone. So reciprocity may influence behavior, in the both way, but international humanitarian law duties do not legally depend on an adversary's compliance. Durable restraint normally combines several pathways. So dear participants, we can now start our 4R framework. The first one is rules. You can see in my presentation here is the R1. That means we will discuss 4R. The first R1 is rules. Rules means distinction begins before attack. For example, Israel want to attack Palestine, or some other state party want to attack any other state party. There is an international armed conflict. So first one is they must comply with the distinction, because international humanitarian law does not decide which party has the just cause. It limits the suffering once conflict exists. Who is correct? It is not the decision of the international humanitarian law. They always try to limit the suffering of the civilians when any conflict exists. So distinction is very important here. We can say its protections do not disappear because an opponent violates the law. Distinction is the starting point for every attack. Parties must separate civilians from combatants, civilian objects from military objects. A mosque, a school, a hospital, these are not a military objects. These are absolute civilian objects. So distinction is must here. Any attacker, any state party who are using force, they must differentiate between civilian object with military object. Indiscriminate attacks are prohibited according to the United Nations Charter, because they are not directed at a specific military object, or their effects cannot be limited as the law requires. For example, suppose information suggests that a fleeing position is near a school, but the attacker must verify the target and assess civilians' presence there. If reliable verification is impossible, suspicion alone cannot make the attack lawful. It is the international humanitarian law according to the Geneva Conventions. So, dear participants, sometimes there is a barrier. It was said that some objects, they are used for the dual purposes. So we claimed here, we said here, dual use does not mean there is no protection for civilians. It is a very acceptable principle of law. The expression dual use here, it is a common public debate, but it is not a treaty category that automatically removes civilian protection who are residing within a military school. In that situation also, there are some exceptional cases. So we said here, an object becomes a military objective only when two legal conditions are satisfied. There are two legal conditions for the satisfaction. First one is, by its nature, location, purpose, or use, it must make an effective contribution to military action. Number two, second condition is its destruction, capture, or neutralization must offer a definite military advantage in the circumstance ruling at that time. A bridge on a river used by civilians and military forces may satisfy these conditions during an operation, but not forever. Even when the breach becomes a military objective, proportionality and precautions still apply. It is a very known, very important terminology, proportionality. We made a separate slide here. You can see proportionality means excessiveness, not arithmetic. Proportionality, I don't know the exact meaning of Indonesian here. Proportionality means, for an example, I can give a simple example. A simple state, for an example, there is a two countries, Israel and Malaysia. Malaysia sent a missile to Israel, just only one missile. So, according to the proportionality rules, Indonesia also can send back a missile or two missiles to Malaysia. But just Malaysia sent a missile. For this reason, Indonesia cannot destroy whole city, cannot destroy, cannot kill hundreds of thousands of people there. It is against the proportionality rules. It is a strict rules of international humanitarian law. But unfortunately, when we can see the practices of the world in Israel-Palestine example, in other armed conflict example, just claiming proportionality, they are doing very illegal activities there. So we said here, proportionality does not require equal losses, and it is not a numerical comparison of civil and military casualties. It prohibits an attack expected to cause incidental civilian death, injury, or damage that would be excessive in relation to the concrete and direct military advantage anticipated. So the assessment is made before the attack using information available at the time. Consider a small military position inside a densely occupied building. It may be lawful target according to the military object, but yet expected civilian harm may make the attack excessive. So foreseeable indirect effects such as an electricity failure, disrupting water or hospital services also require assessment. So scholars disagree about the exact scope of incidental harm. This should be presented as a genuine debate, not as a settled law. So dear participants, dear guests, dear students, we said here precautions require constant care before and during attack. If any state party, they follow these rules, that means rules 1, precautions, then civilian will be protected in a big number. You can see we said here, there are 4 or 5 processes we made here. You can see verify, choose, warn, reassess, and cancel suspend. If there is a 1% confusion that civilian maybe will be killed or will be sufferer, then your attack should be suspended. This is the international law. Precautions transform general protection into operational decisions. So parties must take constant care to spare civilians and civilian objects and must take all feasible precautions in attack. These duties include verifying the target, choosing means and method that reduce civilian harm, and giving effective advance warning when circumstances permit. So in urban warfare, sometimes you can see one strike can disable a city. Any party can say we are attacking just only one object. No, in a city, one attack may harm civilians far beyond the blast area. Why United Nations published there, that means in every 14 minutes, one persons are dying, because there is no specific application of international humanitarian law according to the Geneva Convention, according to other legal justification. So we said here, the distinction is must. This is rules. Urban warfare places civilians, military objectives, and interconnected services within the same space. As you can see here, residential holding, military objective, hospital, water farm station, power substations, all are interrelated with. Just one strike to the electricity or substation you hit, the whole city will be sufferer. So harm may travel through infrastructure system. Damage to one electricity substation may stop water farms, interrupt hospital care, even and increase disease risk. So these are often called indirect or reverberating effects. When foreseeable, they must inform proportionality and precaution assessments. In the 2022 Political Declaration on Explosive Weapons in Populated Areas promotes stronger civilian protection practices. It is a political commitment, not a treaty ban or exclusive weapons. So another part, it is very unfortunate part, medical care requires negative and positive protection. But unfortunately, in a practical current situation, we saw the very bad example in Israel-Palestine conflict. Israel authority made a very obstacle to reach the medical assistance to the sufferer, to the victims. So we said here, international humanitarian law requires the wounded and sick to be respected, to be protected, and to cared for without adverse distinction. This is the law. Medical personnel always will be protected. Units and transports receive special protection because healthcare must remain available amid conflict. Protection has a negative aspect also. Parties must not unlawfully attack or obstruct medical services. It also has a positive aspect. Parties, that means state parties to any armed conflict, must respect and protect medical care and facilitate its humanitarian function. A hospital does not lose protection merely because it treats wounded fighters from both sides. Protection may cease only if the facility is used outside its humanitarian function for acts harmful to the enemy and the applicable warning requirements are satisfied. So, dear participant, we said here starvation and humanitarian access. Here, consent is not absolute because, as you can see, for the protection of civilian, it is the international humanitarian law which one prohibits using starvation of civilians as a method of warfare. It also protects objects indispensable to survival, including food, crops, livestock, and drinking water system. When civilians are inadequately supplied, impartial humanitarian relief may become essential under treaty and customary rules, specifically international law. Relief operations normally require consent, but consent is not unlimited political discretion and may not be withheld arbitrarily. Unfortunately, in the practical situation, we see the difference. Parties may inspect consignments, arrange routes, and impose genuine security controls. These measures differ from blocking food or medicine to pressure a population. For example, checking aid at a crossing may be lawful, but deliberately delaying all deliveries until food becomes unavailable may not be legal. It is totally prohibited. So, dear participants, detention, the missing and families remain protected. It is also another very important universal principle of law according to the international humanitarian law, according to the Geneva Conventions. Protection does not end when shooting stops or a person is captured by other party. For an example, any Hamas people captured by Israeli IDF or any Israeli people captured by Hamas people, it doesn't mean that their protection will be ended. No. Detention and the missing and families remain protected according to the Geneva Conventions and international humanitarian law. Detainees must be treated humanly. It is the very principle of international human rights law. Torture, cruel or humiliating treatment, hostage taking, and convictions without essential judicial guarantees are totally prohibited according to the law. Detailed detention rules depend on the conflict, the person's status, and the applicable legal framework. Parties must also record and share relevant information, search for missing persons, respect the dead and help families learn relatives fed. As you know, in a modern day, in this globalized world, there is organization ICRC, International Committee of Red Cross, and they are trying to apply these rules. There are several debates, there are several limitations, however, we'll discuss later. Here we said new technology, old principles. That means in a modern globalized world, armed conflicts are different with before, because we now see the drones, we see the artificial intelligence system, we can see the cyber operations. So we said here, international humanitarian law also applies to drones. International humanitarian law also applies to artificial intelligence systems. International humanitarian law also applies to cyber operation used in armed conflict, because technology is not lawful or unlawful by itself. Legality depends on its design. Legality depends on its use. Legality depends on its foreseeable effects. So drones may improve observation, but distance and speed may weaken contextual understanding. Artificial intelligence tools raise questions about data quality, bias, predictability, and meaningful human judgment. Cyber operation may disturb hospitals, electricity networks, other civilian service without a conventional explosion. For an example, an algorithm identifying an ambulance supplies information. It does not supply legal permission to attack. Human verification and legal assessment remain necessary according to the modern international law. Dear participants, here very important point of the international humanitarian law. We said armed groups are bound, but not every breach is a war crime. This who is bound? We said here, you can see my picture here. Non-state armed groups are also bound. For example, PKK within Turkey or any other rebellion group within a particular country. They are non-state armed groups. They are also bound to follow the international humanitarian law according to the Geneva Conventions and other international legal arrangements. So we said here, international humanitarian law binds non-state armed groups that are parties to non-international armed conflict. Common Article 3 established minimum human treatment rules. Additional Protocol 2 to the Geneva Convention applies when its conditions are met, and customary law adds further duties. So these rules do not grant recognition or statehood. Humanitarian dialogue can occur without taking sides. Effective compliance. Okay, we are trying to, there is a, okay, thank you. We are trying to finish. Dear participants, we said here armed groups are bound, but not every breach a war crime. And later on, we said there is a no single world court, as you know, International Court of Justice, ICJ, International Criminal Court. They have separate jurisdiction, but there is no specific international single international court which with authority over every dispute, crime, and remedy. So International Court of Justice decides disputes between states and gives advisory opinions. International Criminal Court determines individual criminal responsibility regarding any armed conflict. There are several already decisions we saw. There are several decisions came from the International Court of Justice, even in the occurrence of even regarding the Israel-Palestine armed conflict, Ukraine-Russia armed conflict, and others. You can see the decisions given by the International Court of Justice. So you can say ICJ is playing very important role within their several limitations to play important role for the protection of civilian. And another very important example, we can see here the Gambia versus Myanmar case. As you know, Myanmar is a member country of ASEAN, as well as it is a neighbor country of Indonesia. So there is a very big genocide against the Arakan Muslim peoples there. So Gambia filed a case against Myanmar within the International Court of Justice, and ICJ later found the jurisdiction within this matter. And several examples due to the limitation of time, I am making speedy presentation here. You can see DRC versus Uganda. It is also very known case before the International Court of Justice regarding this matter. And another example we have provided within the framework of the International Criminal Court. As you know, International Criminal Court is not a first station to deal with the armed conflict. It is the last station. If any particular country like Indonesia or any other member country fail to trial any war crime or other 5 types of crime, like genocide, crimes against 4 types of crime: genocide, crimes against humanity, war crimes, and aggression. So ICC has very limited jurisdiction within these 4 types, but it is also playing very important role specifically regarding the individual criminal liability. We will present some specific examples after some slide. So we said here complementary principle is a very known principle of the International Criminal Court. As you know, complementarity. That means ICC cannot deal with any particular armed conflict fastly. First, the particular state party will try to make trial. Otherwise, International Criminal Court will enter. And here we said Bangladesh-Myanmar case is an example. Jurisdiction can flow a cross-border element. As you know, Bangladesh is a member country of the ICC, whether Myanmar is not. But even though International Criminal Court decided that they have jurisdiction under this principle. And here we said one court can recognize different forms of harm. You can see here are 4 examples in this picture. Number 1, Antiganda. Antiganda is a very known chief of the armed forces, Rwandan commander. His name is Antiganda. ICC, International Criminal Court, convicted against him on 18 counts. This is a successful history of the ICC. Al-Mahdi case, international attacks on historical and religious monuments in Timbuktu. So International Criminal Court convicted against him. Nguyen, and Abdul Rahman convicted on 27 counts, sentenced to 20 years. So these are the successful history of the International Criminal Court for the we can see indirectly for the protection of civilian. And beside the ICJ and ICC, there are other platform like national, hybrid, and universal justice carry most cases. Like domestic courts are also often closer to evidence, witness, affected communities, and local legal systems. And we provided some examples like Colombia's special jurisdiction for peace combines victim participation with restorative sanctions and issued its first sanction in 2025. So there are several examples. Now we said we can enter to the another R, that one is response. It is also another framework for the protection of civilian. We said here we now move to response. A court may declare a breach and order. So response is very important. It cannot by itself arrest a suspect, deliver relief, protect a witness, or reform an institution. States must provide the enforcement bridge through legislation, evidence, arrest, surrender, and implementation. So ICC has no police force, as you know. Even International Court of Justice has no police force. So Rome Statute Article 86 therefore requires state parties to cooperate fully with the court. I can give an example for you. For example, ICC announced arrest warrant against Netanyahu for the reason of genocide against Palestinian people. But unfortunately, due to there is no any police force of the ICC, no one can arrest Netanyahu. So a warrant is more than a statement, but less than an arrest. National authorities must locate and surrender the person. United Nations organs, humanitarian actors, civil societies, and communities also contribute through their mandates. So then only response will work, otherwise no. Here is Article 94 connects law to diplomacy. We said here diplomacy is also very important tool for the protection of civilian in the current armed conflict world. A final ICC judgment is not merely advice to the states involved. Article 94 subsection 1 of the UN Charter requires every UN member to comply with an ICC decision in any case to which it is a party. But unfortunately, in practice, we saw that International Court of Justice provided decision against Israel to stop genocide in Palestine or to stop attacking on Palestine, but Israeli authority denied to follow. It is the violation of UN Charter. So if a party fails to perform obligations under a judgment, the other party may approach the Security Council under Article 94. Yes, I'm making very last some slides here. Security Council power and the wider UN tool. So we said here the Security Council is a very important tool, and protection on the ground, warning, presence, and access. Third states are not mere spectators. We said here the protection on the ground, warning, presence, and access must be there. And third states are not mere spectators. Then we said evidence is part of response, not an afterthought. Redress is the last our framework, last R, more than money, more than punishment. So we now reach the redress. Punishment addresses an offender's responsibility. Redress begins with victim's harm, dignity, agency, and security. So state responsibility may require cessation, guarantees of non-repetition, restitution, compensation, and satisfaction. According to Rome Statute Article 75 also identifies restitution, compensation, and rehabilitation. So redress is very important framework of the 4R framework. And redress closes the prevention loop. And it is the last slide of my presentation. We can say in the last, as a conclusion, when law meets war, there are four closing propositions. We can see rules protect civilians when principles become feasible choices before and during action. Number 2, rulings clarify state or individual responsibility, but courts cannot implement decisions alone. Third, response depends on cooperation, capacity, evidence, humanitarian access, and action by states and United Nations. And lastly, redress recognizes victims, repairs harms, converts experiences into learning and better prevention. So in total, rules, rulings, response, and redress, 4 R's form both a chain and a cycle. When one link fails, legal authority may remain formal while civilian protection fail in practice. So our responsibility is not only to ask whether the law was correctly stated, but whether it changed conduct and reduced human suffering. Civilian protection is where legal authority becomes human safety. So in a last sentence, we can say international law has some effects, but there are several debates, there are several limitations of international law we can see in the practice. But my last word is something is better than nothing. Yes, international law has some limitations. International law has some restriction, specifically in the field of armed conflict, in the field of humanitarian law. Even though we can say something is better than nothing. Something is better than nothing. It is my last appeal to you. Thank you for listening me, and thank you for inviting me here. Thank you all and for listening me.
Well, thank you so much, Professor Mahmudul Hasan from Karabakh University. I would like to extend my sincere congratulations on a truly remarkable presentation today. We are learning a lot from your presentations. Ladies and gentlemen, as our Dean of Law Faculty already write in the Zoom, in the chat box in the Zoom, the summary of presentation of Professor Mahmudul Hasan today in Bahasa Indonesia. Now I would like to make it a very short summary of Professor Mahmudul Hasan presentations about civilian protections in armed conflict through the 4R framework: rules, ruling, response, and redress, with over 37,000 recorded civilians deaths in 2025, one every 15 minutes. The presentation stresses that legal compliance is not merely theoretical, but must bridge the operationals last mile on the ground, addressing challenges like dual-use object, reverberating effects in urban warfare, humanitarian access, and new technologies. While international judicial bodies have distinct mandates, effective protections ultimately depends on genuine cooperations among states and institutions, and most importantly, the ability to translate legal obligations into actual operational decisions that change conduct and reduce human suffering. The Bahasa Indonesia is already in the chat box, so you can read in the chat box for the translations. And once again, thank you so much for your remarkable presentation, Professor Mahmudul Hasan. And again, it is very nice again to meet you in our second seminar today. Thank you. And ladies and gentlemen, I would like to invite our next honorable speaker from Universitas Pancasakti Tegal, Indonesia, Ibu Kanti Rahayu, SHMH. You have 15 minutes for your presentation. Thank you. Please do.
Oke. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Thank you for the opportunity provided, Ms. Yoga, distinguished Rector, Dean of Law Faculty, speakers, lecturer, and students. Good afternoon. Allow me to present today's discussion material with the title Protection of Civilian in Armed Conflict and International Humanitarian Law Challenges and Humanitarian Responses. It is a pleasure to be here with all of you today. As university students, you are not only future professionals, but also future scholars, policymakers, lawyers, and leaders. Therefore, I would like to begin today's discussion with a simple but difficult question. When war happens between states, who actually pays the highest price? The answer is often very clear: civilians. Ladies and gentlemen, over the last 3 years, we have witnessed serious armed conflict in different parts of the world. We have seen civilians killed, families forced to leave their home, children deprived of education, hospital damage, and humanitarian assistance disrupted. These are not merely numbers reported in the news. Behind every number, there is a human life, a family, and a future that has been lost uninterrupted. And over the last 3 years, the war situation, like in Gaza, in Iran, make us just woken up. Is international law still functioning? What makes this situation particularly important for us to discuss is that international law already provides rules to protect civilians during armed conflict. So, who is a civilian? A civilian is a person who is not a member of the armed forces. Civilians are protected under international law, especially humanitarian law. Protection applies unless and for such time as a civilian directly participates in hostilities. Children, women, older person, and person with disabilities may face additional risks. Next, why does civilian protection matter? Civilians often bear the greatest human cost of armed conflict. They may face death, injury, displacement, hunger, and loss of basic services. Protection of civilians is both a legal obligation and humanitarian responsibility. So, international humanitarian law seeks to limit human suffering during war. International humanitarian law establishes important principles, including the principle of distinction between civilian and combatants, the principle of proportionality, and the obligation to take the principle and precaution during military operation. So, what is international humanitarian law? International humanitarian law is the body of international law that regulated armed conflict and seeks to protect people affected by war. Its main purposes are, first, protect civilians and persons who are not or are no longer taking part in hostilities. Second, limit the method and means of warfare. And the last, reduce unnecessary suffering. But here this problem, if international law already provides protection, why do civilians continue to become the primary victim of war? This question brings us to the central issues of our discussion today, the gap between international legal norms and their implementation. International law can establish obligation, prohibit certain conduct, and declare that civilians must be protected. But law is meaningful only when it can influence the behavior of those who possess the power of wage war. Okay, next. The legal foundation. The protection of civilians is primarily based on, first, the Geneva Convention 1949, of course, with additional protocol of 1977. The Geneva Convention and their additional protocol were developed precisely because the international community recognized that even during war, there must be limit to violence. But here, this problem, if international law already provides protection, why do civilians continue to become the primary victim of war? International law can establish obligation, prohibit certain conduct, and declare that civilians must be protected. But law is meaningful only when it can influence the behavior of those who possess the power to wage war. And this is where the problem becomes much more complicated. The international legal system does not operate like a domestic legal system. There is no single global government, no universal police force, and no centralized authorities capable of immediately stopping every violence. International institutions are also influenced by political interests, state sovereignty, geopolitical competition, and the structure of international decision-making. So, very important, to implementation the principle of distinction. Parties to an armed conflict must always distinguish between civilian and combatants. When the civilians brought the gun, so it automatically become combatants, civilian object and military objectives. Civilians and civilian object must not be deliberately targeted. And then the principle of proportionality, an attack is prohibited if it is expected to cause first, excessive civilian death or injuries or excessive damage to civilian object. The principle of precaution before and during an attack, parties should first take visible measure to protect civilians. Second, verify that the target is a legitimate military object. Third, choose means and method that minimize civilian harm. And the fourth, give effective warning when circumstances permit. Therefore, when a state violates international law, the question is not simply, is the conduct illegal? We also need to ask, who will enforce the law? And perhaps even more importantly, what happens when the mechanism of enforcement themselves are constrained by political interests? Who needs special protection? In international humanitarian law, special attention is required for children, women, older person with disabilities, refugees and internally displaced person, and person deprived of liberty. Humanitarian challenges today is about urban warfare, forced displacement, attack on critical infrastructure, restriction on humanitarian access, cyber operation, misinformation, and emerging technologies. For us as students, this issue is important because it teaches us that studying law is not simply about learning what the law says. We must also examine whether the law works in practice, why it sometimes failed, and what can be done to make it more effective. Today, I invite you not merely to look at armed conflict from a political or military perspective. Let us look at it from the perspective of humanity, dignity, legal responsibility, and the protection of civilians. When we talk about the protecting civilians, requires more than legal rules. It requires first respect for international humanitarian law, second investigation of alleged violations, third accountability for serious crimes, fourth access to justice for victims, and the last international cooperation. War does not mean impunity. Because ultimately, the credibility of international law should not be measured only by the number of conventions that states have signed it. It should be also states have signed it. It should also be measured by a much more fundamental question. When civilians are in danger, are international actually protect them? That is the question I would like to explore together today. And now the conclusion is protecting civilians is a legal obligation and a moral responsibility. To strengthen civilian protection, we need first stronger compliance with international humanitarian law. Second, effective humanitarian access. short accountability for violation, and greater protection for vulnerable groups. And the last, international cooperation and political commitment. Even in war, humanity must remain the limit. I think this is all that I can share. I'll hand it back to Miss Yoga. Thank you, Miss Yoga.
Thank you so much, Ibu Kanti. What a truly inspiring presentations. Well, ladies and gentlemen, I think that the presentation is easily understood by you. Ibu Kanti, our beloved lecturer, she talks about, let me say in Bahasa Indonesia, hukum apa tadi, humanitarian international, yang tujuannya adalah melindungi warga sipil dan orang-orang yang tidak atau tidak lagi ikut serta dalam permusuhan, membatasi metode dan sarana peperangan, mengurangi penderitaan yang tidak perlu. She also talks about who needs special protections in war, like children, women, older persons with disabilities, refugees and internally displaced persons, and persons deprived of liberty. Ibu Kanti, would you mind sharing your presentations in a Zoom meeting? So perhaps your students needs it to make more questions about your inspiring presentations. And also you are talking about protecting civilians requires more than legal rules. It requires like respect of international humanitarian law, investigations of alleged violation, and so on. So as you mentioned already in in your presentation. So ladies and gentlemen, we still have 121 or 22 now, 22 participants. So you are very enthusiastic. I'm happy because all of you are still here to listen and listen carefully and to learn more about the last presentations from our honorable keynote speaker today from Lazarski, Poland, Lazarski University, Poland. We have been cooperating with the Lazarski University for years. I would like to invite Assistant Professor Dr. Carlos Starzala. I don't know how to pronounce it. Correct me if I'm wrong. Thank you for being here. You have 15 minutes to present. Please do. Thank you.
Hello, good afternoon, everyone. Good morning in Poland, it's like 9:15 a.m. Can you see the presentation?
Yes, clearly. Yes.
All right. So thank you for kind introduction, rector, professor, dean doctor, distinguished colleagues, and dear students. Salamat siang. It's a true honor to speak at your international seminar. I'm glad because while my studies in Singapore, I have visited Indonesia a few times, so I hope to visit it again, maybe someday at your university. It's morning in Poland, so you are my first word. You are receiving my first word of the day, and I promise they will be all yours. I would like to tell you a few words about following the money in the times of conflict. So over the next 20 minutes, I want you to take you on the chase after money through banks, through ships and sea, and through blockchains. My argument is simple, and I will repeat it at the end. In modern conflicts, sanctions are not only as effective as our ability to follow the money, and that ability is being tested right now by crypto assets. Let me begin with the story, the biggest thief in the history of money. At 21st of February 2025 in Dubai, the crypto exchange Bybit is making a routine transfer between their own wallets. The employee who approved the transaction see a normal, legitimate transfer on their screens. Everything looks correct, but the website interface they are using has been secretly modified. What they actually sign is something completely different. Within minutes, around $1.5 billion in Ethereum leaves the exchange. No guns, no mask, no getaway car, not even a bank. And it is the largest single thief in the history of money, bigger than any bank robbery ever. And here's a part that matters for this seminar. The thief was a state. FBI attribute the attack to the Lazarus Group, hackers who works for North Korea, a nuclear-armed country under the heaviest sanctions of Earth. According to TRM Labs, within 48 hours, at least $160 million had been funneled through illicit channels, and within 5 days more than 400 million have been moved. United Nations experts assess that this money funds North Korea's weapons programs. So when we talk about sanctions, money laundering, and crypto assets, we are not talking about abstract compliance rules. We are talking about how state finances conflict in the 21st century, and whether the law can keep up. Keep up with this Bybit case in mind. We'll come back to it. Before we follow the money any further, we need one legal distinction. It sounds technical. It is not. It decides everything else I will say today. There are two families of sanctions, and they are legal, very different animals. The first family, United Nations sanctions. They are adopted by a Security Council under Chapter 7 of UN Charter, and they are binding on all 193 member states, including Indonesia, including Poland, including everyone in this room. But there is a price. Any of the 5 permanent members, the United States, Russia, China, France, and the United Kingdom, can veto them. The second family, autonomous sanctions, sometimes called unilateral. They are imposed by individual states or blocs under their own domestic law. In the United States, it's under the International Emergency Economic Powers Act. In European Union, through Common Foreign and Security Policy. They bind only the states that adopt them, and controversially, then they sometimes reach third parties through so-called secondary sanctions. Why does this matter so much? Because of the fact that surprised many of my students in Warsaw, there is not a single United Nations sanction against Russia for the invasion of Ukraine. Not one. Russia sits in the Security Council and votes them. Everything you have heard about the SWIFT exclusion, the oil price cap, the frozen assets, all of it belongs to the second family. And this is why the map of sanctions looks the way it does. For Europe and North America, sanctions Russia feels like a global effort. Seen from Jakarta, from Tegal, from most of the world, it is not. In ASEAN countries, only one member state, Singapore, has imposed sanctions on Russia. Indonesia has executed decline in line with its free and active foreign policy. Jakarta positions legal presses. Only binding Security Council resolutions must be enforced. Everything else is a sovereign choice. I want to be clear, it is not a criticism. It is a legal, coherent position, and it is exactly what the two families' distinctions predicts. But it has consequences for enforcement, and we'll see them in a moment. Meanwhile, when the Security Council locks, enforcement migrates outside it. Two examples. First, repo. The task force of G7, the European Union and Australia, has frozen more than $58 billion belonging to sanctioned individuals and impoverished around $300 billion of Russia's central bank reserves. Second, North Korea. In March 2024, Russia voted to the renewal of the UN panel of experts that had monitored North Korea sanctions for 15 years. The panel died. 11 countries then create the replacement outside the United Nations, the multilateral sanction monitoring team. The lesson is that the architecture of enforcement is moving from universal institution to coalitions of the willing. So how does money actually escape sanctions? Let me show you the old roads first, ships and papers. The ships, like Russia sells, it's all above the price cap using a so-called shadow fleet. Aging tankers with obscure owners, flags of convenience, transponders switch off. The European Union has now lists around 440 of these vessels. The United Kingdom has designated around 135 tankers, which by London's own estimates. Paper is like re-export through third countries. A washing machine flies to a third country as a washing machine, and its microchips continue the journey east. The US Bureau of Industry and Security formally lists 18 common transshipment points for restricted goods heading to Russia. A list that includes major trading nations across Asia, Middle East, and Europe. And I say this with respect. Geography and open trade, not bad intent, but countries on that list. These roads are old. What is new is the third road, crypto. Here are the numbers, and they are fresh from the Chinese crypto crime report published in January this year. In 2025, addresses linked to leaked activity received a record of $154 billion in crypto assets. That is an increase of the 162% in a single year. What drove it? Above all, sanctioned entities. The value received by sanctioned actors surged by almost 700%. And the vehicle of choice has changed. Bitcoin is no longer a star of financial crime. Stablecoins, which are tokens pegged to the US dollars, mostly Tether on Tron network, now account for 84% of all leaked transactions volume, up from 63% just a year earlier. Think about the irony of the moment. The most effective tool for escaping American sanctions is digital American dollar. Now the number on the other side, because I promise you the honesty. All of this illegal activity remains below 1% of total on-chain volume. Crypto is not mainly a criminal economy, but its criminal corner is growing fast and is increasingly state-linked. That is a real danger, not the size, but who is using it. Let me make this concrete with one case you have probably never heard of, and it may be the most important financial innovation of the war in Ukraine. It is called A7A5, the stablecoin backed not by dollars, but by Russian rubles, with reserves held at the sanctioned Russian bank, Promas Bank. It was issued in Kyrgyzstan, in Central Asia, and it runs mainly on the Tron and Ethereum blockchains. In less 1 year, A7A5 processed more than $93 billion in transaction. And at its peak, it moved around $1 billion a day. It became the settlement rate for Russia cross-border trade that banks could no longer touch. Its natural home was Garantex, a Russian exchange, which was sanctioned in 2022, which nevertheless processed $96 billion over its lifetime. How just by hiding inside larger platforms as so-called nested service and by changing its wallet's addresses every single day to stay ahead of compliance software. In 2025, in August, the United States sanctioned A785, its issuer and its network. The European Union and UK followed it in October. Their daily volumes fell by roughly half, significantly, but not fatal. And when Garantex itself has taken down, a successor called GreenX appeared within weeks. This is a pattern I want you to remember. Designation, adaptation, and redesignation. The chase does not end, it accelerates. Which brings us to the question, is law and law enforcement actually winning any rounds? Yes, but here are 4. Round 1, Binance. In November 2023, the world's largest cryptocurrency exchange agreed to pay approximately $4.3 billion to the United States, the largest settlement of its kind in American history. Binance had filed to report more than 100,000 suspicious transactions, including transfer linked to Hamas, Al-Qaeda, ISIS. So its founder, Chaping Zhao, pled guilty and stepped down. The message was like, no platform is too big for anti-money laundering law. Round 2, Garantex take down. In March 2025, prosecutors and police from United States, Germany, and Finland seized its servers and froze $26 million. One of its administrators was arrested in India. Cross-border enforcement works. Slowly, but it works. Round 3, and this one deserves special attention in every law faculty. Tether, the private company that issues the USDT stablecoin, froze $28 million sitting in Garantex wallets. Think about what that means. A private issuer acting in effect as an enforcement arm. In the world of stablecoins, the choke point is not the court, it's a company. And round 4, evidence. The Bybit investigation was cracked within days by blockchain analytics firms and even by one independent online investigator, on-chain forensic. Following transactions across public ledgers has become a new evidentiary standard, feeding directly to sanctions, designations, and criminal indictments. But now comes the hardest legal question of all. Can you sanction computer code? In August 2022, the US Treasury designated Tornado Cash, not a person, not a company, but a piece of software, a mixer, a protocol that pulls crypto from many users and pay it out to fresh addresses, breaking the chain of traceability. Tornado Cash was allied to have laundered more than $1 billion, including hundreds of millions stolen by North Korean hackers. It was the first time in history that sanctions targeted an autonomous protocol. Then the court spoke in November 2024 in the case called Van Loon versus the Department of the Treasury. The U.S. Court of Appeals for the 50th Circuit wrote that immutable smart contracts, codes that no one owns and no one can change, are not property under the sanctions statute and therefore cannot be designated. In March 2025, the Treasury removed Tornado Cash from the sanction list, although a later court injunction showed the question is not only settled and redesignation remains legally untested. Please pause on this for a moment. For centuries, sanctions have targeted persons, entities, or states, subjects of law. Tornado Cash forced a court to ask whether software itself can be a subject of sanctions at all. The judges said no. But the people who write such software, that's a different story. And it produced 2 trials on 2 continents with two very different endings. Alex Pertsev, one of the developers of Turner Cash, was tried in the Netherlands. In May 2024, a Dutch court convicts him of laundering $1.2 billion and sentenced him to 64 months in prison. The court's view, in its own words, the mixer was a tool intended for criminals. Next, Roman Storm. His colleague was tried in New York in August 2025. The jury convicted him on one count only: conspiracy to operate an unlicensed money transmitting business, and could not reach the verdict on money laundering or on sanctions validation. As of this spring, prosecutors were seeking a retrial in case it's still moving, so please treat this as unfinished law. Some software, broadly the same facts, two jurisdictions, two philosophies. Europe asked, what did your tool do? America asked and could not fully answer. What did you, the author, intend? Dear colleagues, for your students, I cannot imagine better examination material. Where exactly does writing software end, and where does financial crime begin? There is no settled answer yet, which is the perfect moment to ask the uncomfortable question about this entire field. Do sanctions actually work? The honest answer, partly, slowly, and never alone. The costs are real. The Bank of Finland Institute for Emerging Economies estimates that Russian growth fell to about 1% in 2025 from nearly 5% of year before. Russia's liquid rainy day fund has shrunk from 6.5% of the GDP before the invasion to under 2%. A global export to Russia of the high priority battery goods, the microchips, the optics, are down roughly 40% from pre-war levels. That is real pressure. But the academic literature is humbling. The classic study of Hubbayer and colleagues, covering 174 historical cases, found that sanctions achieved their goal in about 1/3 of cases. And one famous critic, Robert Pape, argued that true success rate was closer to 4% only. Sanctions rarely change regime behavior by themselves, and their power erodes within broad participation, which brings us back respectfully to this region. When most of the world states, entirely lawful, do not apply autonomous sanctions, the sanction money does not disappear. It reroutes through new banks, new flags, or new tokens. My own view, and I offer it for your debate, sanctions are not a switch that stops the war. They are a tax on aggression, cumulative, leaky, but real. And that tax has more requirement. It must not fall on the innocent. Because there is a humanitarian side to following the money, and it belongs at the heart of this seminar team. When banks fear sanctions, they overcomply. They de-risk, they refuse entire countries, entire categories of clients, including humanitarian organizations trying to pay for food, medicine, and shelter in conflict zones. The aid does not flow, and no sanctions ever intended that. A Security Council answered in December 2022 with Resolution 2664, a standing humanitarian carve-out that applies across US sanctions regimes, adopted by 14 votes to 0. In 2024, Resolution 27621 made that exemptions undefinite for the ISIL and Al-Qaeda regime. The European Union has transported the same logic into its own sanctions law. The principle is simple, and I would like you to keep it next to the Bible story. Following the money must never mean freezing the ambulance. A sanction system that starves civilians is not only cruel, it loses the legitimacy on which, as we have seen today, its global acceptance depends. Let me finish where enforcement will actually happen next. Just here. Indonesia, it's not only a sidelines of the story, it's moving to the center. In October 2023, Indonesia became the 40th full member of the FATF, Financial Action Task Force, the global standard setter for anti-money laundering. In January 2025, supervision of crypto assets moves from BAPET-T, the commodities regulator, to OJK, the Financial Services Authority. That is a profound reclassification. Crypto is no longer a commodity you trade, it is a financial asset you supervise. You know your customer duties, and with suspicious transaction reports flowing to your financial intelligence unit. And the scale is remarkable. By late 2024, more than 21.5 million Indonesian held crypto assets, with monthly transactions of around 48 trillion rupiah, roughly $3 billion every month. So let me close the loop. Remember, Bybit, $1.5 billion stolen by a sanctioned state, laundered through mixers and stablecoins, and yet traced, partly frozen and prosecuted because investigators could follow the money on a public ledger. That is the whole story on this field in a single case. 3 things to take home. First, always ask which family of sanctions you are looking at. A Security Council resolution which binds everyone, or an autonomous measure that binds some. The answer explains most of world politics around sanctions. Second, the money has moved to rares. The law is still learning. Stablecoins, mixers, shadow exchanges. The enforcement increasingly runs through private companies and public blockchains. And third, effectiveness is a product of 2 factors: participation and traceability. We can either one, and the system leaks. So in times of conflicts, sanctions are only as effective as our ability to follow the money. Thank you very much for your attention. Terima kasih banyak. I look forward for a question. Thank you.
Thank you. Terima kasih banyak. That's nice words coming from you. Thank you. You learn a lot about Indonesians bahasa or Indonesian's language, Professor Carol Zala. Well, ladies and gentlemen, finally, we have we have been listening well for the 3 keynote speakers today. But before we move further, I forgot to introduce you about the short biography of Professor Carol Zala. How can I pronounce your name? Kindly teach me.
It's Strała. Yeah, literally Strała in Polish means arrow in English. Arrow.
Oh, arrow. Okay, that's nice. Okay.
Arrow.
Carol Arrow. Okay, that's nice. Thank you so much, Professor Carol Sarla or Arrow. Well, ladies and gentlemen, operator, please, I would like to introduce Professor Carol Sarla. Thank you. Well, ladies and gentlemen, here is the short biography of Professor Carol Sarla, he is an economist and lawyer, director of the master's program in FinTech and Finance at Lazarski University in Warsaw, where he lectures on corporate and business law, AML or CFT, and finance. He holds degrees in finance from SGH Warsaw School of Economics and in law from Lazarski University, and was an exchange scholar at Singapore Management University. His doctoral dissertation examined implementations models of central bank digital currencies. One of the most one of the most closely watched topics in contemporary monetary policy. He combines academic works with business practice and board-level experience in corporate governance. Thank you. Well, it is again nice meeting you, and again, I would like to express our sincere gratitude of your remarkable presentations today about international law in economics and business. I think you are focusing on international law in the economic and digital sphere, specifically how states and international institutions use legal instruments of sanctions, criminal law, and financial security corporations to combat conflict financing, such as funds derived from North Korean hacking groups. That's to my understanding. Correct me if I'm wrong. So you examine international sanction enforcement and AML, or CFT efforts in conflict setting, focusing on the growing role of crypto assets as evasion tools. Ladies and gentlemen, finally, we have come to question and answer sessions, and I believe there are many of the questioners here. We have so many here, okay? Then I would like to invite the first questioner, Farhan. Operator, would you please, on the screen, please, what do you call it, pinned Farhan and also the first speaker, because Farhan question is is addressed to the first speaker. Operator, please. Farhan, are you there? And Professor Mahmudul Hasan, are you still there? Because the question is for you. Hello?
Yes, I'm
Yes,
here.
please. Yeah, okay. And Farhan, please. Operator, bisa nggak berdampingan me, Farhan, and Professor Mahmudul Hasan, so we can like making conversations, discussions. Farhan, yeah, please do.
So, assalamualaikum.
Waalaikumsalam. Okay. No, I asked the operator harusnya berdampingan antara. No, not you. You can continue. Farhan boleh lanjut. I'm asking to the operator. Yeah, please. Farhan, please.
Baik. Assalamualaikum warahmatullahi taala wabarakatuh.
Waalaikumsalam.
Good everyone. Before it all, thank you in advance for the opportunity, and thank you very much for all the speakers for your presentation. It can be useful, meaningful, and it can be our new site about the international law. And my question, before it all, I would like to introduce myself. My name is Muhammad Farhan Amar Muhandis, 21 years old, and I'm still a sophomore from Faculty of Law, Universitas Pancasakti, Tegal.
Yes.
And my question is, it goes to Mr. Dr. Mahmudul Hasan. Referring on your slide about principle of distinction, our international news often report the civilian casualties in counterinsurgency or counter-terrorism operation, but globally, like in Gaza, and domestically, like in Papua, Indonesia, where civilian areas become conflict zones, and when armed actors label their operation as security measures rather than armed conflict. So the question is, how can international law practically how can the international law practically enforce the verification process to protect civilians, especially when targets are located near the school or residential areas? Thank you very much.
Thank you, Farhan. A very good questions,
Yes.
but I think it's really hard to answer. So
Thank
thank you,
very
Farhan.
much.
Yeah, thank you, Professor Mahmudul, please.
Yes, of course. Thank you, Farhan,
Thank
for
you.
your nice question
Yes,
and
anytime.
very time-related question. In simple, we can say international law requires forces to verify that a target is truly military before attacking, especially near schools or homes, as you said in your questions. If there is any doubt or a high risk to civilians, to attack should be delayed, changed, or cancelled. Violations can later lead to investigation and accountability. Again, I am saying in simple sentence, in practice, what it means. It means international law can protect civilians near schools or homes by requiring attackers to verify the target before attacking. So how they can verify? Use reliable information to confirm the military target by using their intelligence or others. Number two, they will check if
Excuse me.
civilians, schools, or hospitals or homes are nearby or not. Number three, delay or cancel the attack if there is serious doubt or high civilian risk. According to Geneva Conventions, it is duty to the state party or any armed party to the armed conflict. They will delay or cancel the attack if there is any simple doubt. Number four, use safer weapons, timing weapons, and they will use methods where possible. And
Excuse
lastly,
me. Excuse me, Professor Mahmood. Please on cam because we would like to see you in answering the question. Thank you. Thank you. I'm so sorry. Thank you.
Okay.
Yeah, it's nice to see your face on the screen. We'd love to see that very much.
Of course.
Yeah, thank you. Thank you so much.
Yes,
Yeah,
dear
that's
Farhan,
nice.
dear
That's
Farhan,
nice.
I have tried to specify that
Mhm.
if international law, they can protect civilians near schools or homes, as you said, by requiring attackers to verify the target before attacking. So this verification process they can do in several ways. We can say 4 or 5 examples. Number one, they can use reliable information to confirm the military target. Number two, they will check if there is civilians, schools, hospitals, or homes are nearby or not. If there is any simple confusion, they must delay or cancel the attack according to the Geneva Conventions. If there is any high civilian risk, they will delay. Otherwise, they will be liable according to the international humanitarian law. International Criminal Court will start proceedings against them if they did so. And they will use safe weapons, timing, and they will use methods where possible. Investigate violations and hold responsible persons accountable. So this is the international legal procedures. There are no other any verification process. So the verifications belongs to the state party. They will use their all kind of reliable information to confirm that the object is military object or civilian object. I think you got the point.
Okay. Yes, we got the point. I think
Thank
double
you
check.
for the answer.
Okay, jadi harus. Okay, understood very well, Farhan.
Yeah, I got it, Miss.
Okay, thank you.
Thank
Very
you
good,
very much for
very
the
good
answer.
student. Thank you, and thank you so much. So I don't need to translate in Bahasa Indonesia if you understand well. Well, we would like to invite next. This is from Milik Muhammad about what protections does the government provide for cryptocurrency investors. Okay. Operator, please. Milik Muhammad. I don't know. A53 the spotlight because I think the questions goes to Professor Carol Starla. Okay, that's very difficult for me. Okay, thank you. Ya, Bapak ya silakan. Would you please talk directly? Thank you. Pak Muhammad, please talk directly. Silakan bicara langsung, Pak Muhammad. Yeah, thank you.
Okay, thank you.
Mhm.
Good afternoon, sir. In your opinion, how should legal protection for cryptocurrency investors be provided in a country, sir? In your opinion?
Okay, that's a question for me. Thank you for this question. That's very important. It's a very important question. So actually, in European Union, we have already introduced few regulations. But let me answer for Indonesia, especially because I have read a lot about it. So because your framework just changed, and it changed in your favor. Since January 25, crypto supervision sits with the OJK, the Financial Services Authority. That reclassification carries real protections. Your platforms, cryptocurrency platforms, must be licensed. Client assets are subject to custody and segregation requirements. Exchange needs to carry know your customer duties, and your all suspicious activity flows to the supervision authority. If the platforms misbehaves, there is no financial supervision to complain. There is now some financial supervision to complain to, and that is the biggest single upgrade. But I must be honest with what no government protects you from. The regulation protects you from the dishonest exchange, not from the honest price collapse. There is no deposit insurance for crypto, no central bank standing behind the token. And if you hold assets in a self-host wallet and lose your keys, for example, for crypto wallet keys, no authority on earth can recover them. So that's bad thing. So the first summary: a state increasingly protects the infrastructure like licenses, custody, and market conduct, but risk remains yours. And that is precisely why this room matters. Investor protection in crypto is being written right now, and it will be written by lawyers. So that's the question. That's the answer to your question.
Okay. Pak Muhammad, so what do you think? So it is still very risky at this time, Professor Carol, for crypto investments in Indonesia, especially in your point of view?
Can you repeat, please, at the beginning?
So it is still very risky to invest crypto in Indonesia, especially to your point of view.
Investing in crypto is always risky, especially because of the
So not only in Indonesia, you mean everywhere
it's not
in the
only
world?
it's all over the world,
Okay,
everywhere. Even Poland, Europe, it's risky all over the world, especially because of a lot of scams. You know, there's a lot of scams in crypto tokens. But it's less risky because right now you have some authority which can control the exchanges.
You mean OJK? You mean OJK here
Yeah,
in
I mean OJK.
Okay. Pak Muhammad, jangan di off dulu kameranya, kan saya belum ngomong Bapak sama Bapak. Oke, Bapak silakan
Ya, itu.
berbicara. Oke.
Karena pakai HP muter-muter terus ini
Muter-muter kayak gini ya. Jadi muter-muter ya. Opan saya juga pusing dari tadi muter-muter. Monggo Bapak, ada yang mau disampaikan? So, beliau menyampaikan sekarang udah agak mending karena ada OJK. Kalau memang semuanya risky banget ya.
Ya memang resikonya masih besar dan perlindungannya masih kurang. I think but I think thanks for your answer, sir, and I hope the regulation if the cryptocurrency investor be provided in country soon.
Okay, thank you, Pak Muhammad. Thank you, Professor Carol, for your question. I'm sorry for your answer, Pak Muhammad di Senada, suatu kehormatan. Bapak semester berapa nih, Pak? Ngomong-ngomong, jadi penasaran. Jadi penasaran. Ngomong-ngomong,
semester 7.
Oh, okay, 7 semester. You're going to have a next. I think cryptocurrency investment in Indonesia will be your next research project. Ya, Pak, nanti jadi tesisnya research tentang regulation of cryptocurrency. Could be your project. Thank you, Pak Muhammad.
We'll keep my fingers for
thank
that.
you. Yeah, thank you, Professor Kara. Well, I have a Okay, Farid Pranoto, saya nggak tahu Bapak atau Mas ini, Miss Yoga, but I think Mas ini ya, Miss karena panggil saya Miss Yoga. I have a question, please. Ini ke siapa ya? Oh, Mahmudul Hasan, Professor Mahmudul Hasan again. Yes, one more. The last question, I think, because the time is nearly over. Ya, bisa dipin, Pak Mas Farid. Ya, okay. Thank you. Mungkin Mbak Amalia nanti kalau waktunya masih cukup ya Mbak Amalia ya. Okay. Professor Mahmudul Hasan, are you here? Sorry,
Yes,
one more
yes, I'm
call.
here. I am here.
Sorry.
Don't worry. I am
Yeah,
here.
on cam please. We would like to see your face again. Thank you. And operator, tadi siapa ya namanya? Kok saya lupa lagi. Mas Farid Pranoto. Mas Farid Pranoto. Yes, please.
Okay,
Silakan.
Miss. So thank you for the opportunity. Assalamualaikum warahmatullahi wabarakatuh.
Kok belum dipin ini?
Waalaikumsalam.
Waalaikumsalam warahmatullahi wabarakatuh.
Um,
On cam Mas, on cam please.
I'm so sorry. Maaf, Miss, aku lagi di luar jadi nggak bisa on cam.
Okay. Ya sudah, nggak apa-apa. Ya, please directly ask the
Yeah.
question. Thank you.
Yes, this is very interesting and excellent discussion. Thank you for the presentation and thank you for the opportunities. It's very important to me to know about the international law, navigating international law in times of conflict and humanitarian challenge. Before I ask a question, I want to say sorry and please excuse me for not turning on my camera as I'm currently not at home.
Okay.
I'm from home actually, so I'm sorry about that.
Mhm.
So we understand and we know that international law is designed to create order and justice among states. However, in several international conflicts, its enforcement appears to be influenced by political interests. So my question is, this is question for Professor Dr. Mahmudul Hasan and Professor Dr. Carol Zasla. I think, what do you think about international law can truly provide justice if its enforcement is still influenced by political interests? That's my first question, Miss. I have two questions.
Yeah. Mhm. Oh, one question only, please. Yeah, because time is very limited. Thank you. Thank you.
Thank you.
You're
Thank you.
welcome.
Okay, thank you very much
Thank you
for
for
your
the
nice
opportunity.
question. Here, I can say for all that the main problem is not the absence of law, but the unequal enforcement of law. So, as you asked that, can international law truly be called as a tool for justice? Whether you can see the enforcement in a big part depends on the political power. So we can say there that international law sets common legal standards for justice and accountability. On the other hand, political power often affects when and how those rules are enforced. So powerful states may sometimes avoid consequences that weaker states cannot. So this phenomena creates selective enforcement and weakens trust in the system. So even though we can see still international law remains important because it provides legal standards, evidence for accountability, and basis for courts and future justice. But as you can see, if you ask me, so what are the problems specifically regarding the enforcement? I can say that first number problem is permanent 5 countries within the United Nations Security Council who are using veto power. So permanent 5 veto power and their political divisions within the United Nations Security Council, they can block referrals, sanction, and other accountability measures. Second one, lack of political will to investigate powerful actors. As I said before, International Criminal Court already announced their arrest warrant against Netanyahu, but no one can enforce it, unfortunately. So, and in the same way, difficulty collecting reliable evidence during conflict. We saw it in the Myanmar example. Weak or biased national justice system who are not wishing to make a trial against any particular leader. Limited cooperation with international courts, it is also another reason. Immunity, amnesties, and protection of senior officials or long delays in investigation and trials. These are the obstacle in this process. And difficulty arresting accused persons, fear and lack of protection for victims and witnesses. So these are the problems. So in last sentence, we can say, yes, there are several political pressures, several problems, but the enforcement of international law, even though we said something is better than nothing. If there is no international law, the problems are much bigger. So it is the conclusion we can say. Thank you.
Okay, thank you for the very good explanations, Professor Mahmudul Hasan. Siapa tadi ya yang nanya ya? Do you understand well? You can't get the point. Could you get the point? Jadi intinya international law itu harus ada ya, no matter what no matter the bias where to go, but international law is still very important. Well, I can't say more because that's I think we have known everything. So sometimes power is everything. Okay. So anyway, thank you. Thank you. Well, ladies and gentlemen, finally we have come to the end of the agenda. I am truly sorry for not be able to give opportunity to all the questioners, especially in the chat box, like Amelia. I'm really sorry because we have a very limited time today. So maybe next time in our next agenda of the international seminar, so you can ask more questions in the near future. On the next agenda of international seminar that will be held perhaps in the or in the guest lecture or public lecture that will be on 27th of August, if I'm not mistaken, will be held by Faculty of Law. Hopefully, again, it is very enthusiastic discussions among the keynote speakers, especially from Poland and from Turkey. Again, we are truly honored for both of you are here, and Ibu Kanti also thank you for the insight today. And I would like to deliver this agenda to the Master of Ceremony, Ibu Ihda Rosdiana. Please do. Thank you.
Thank you very much, Dr. Yoga Prihatin, for moderating today's discussions. And of course, to all participants for your attention, enthusiasm, and also active participations. And on behalf of Universitas Pancasakti Tegal and the Faculty of Law, we would like to express our sincere appreciations to all our distinguished speakers, Dr. Mahmudul Hasan from Karabük University, Turkey, Ibu Kanti Rahayu from Universitas Pancasakti Tegal, Indonesia, and Professor Karol Starzala from Lazarki University, Poland. We hope that today's discussion has not only broadened our understanding of international law in times of conflict and humanitarian challenges, but has also provided an opportunity for meaningful academic dialogue and also strengthened connections among scholars and institutions from different countries. Ladies and gentlemen, now we have reached the end of our international seminar. And before we close, I'd like to take a photo session. So, ladies and gentlemen, everyone, kindly please open up your camera. Operator minta tolong untuk bisa di screenshot. Ladies and gentlemen, please smile to the camera. Okay. Ready? 3, 2, 1. Okay. Lagi, Mas Wirawan? Masih? One more, ladies and gentlemen. 3, 2, 1. Okay, one more, please. 3, 2, 1. Okay, thank you very much, ladies and gentlemen. So, on behalf of the organizing committee and the Faculty of Law, Universitas Pancasakti Tegal, Indonesia, I'd like to thank you all for your presence and participation. We look forward to welcoming you again at our future international academic activities. Have a wonderful afternoon. Stay healthy and see you again. Thank you very much. Bye-bye, everyone.
Bye-bye.
Thank you, Ms. Yoga.
Thank you so much. Bye-bye, everyone. Bye-bye. Bye-bye, Professor
Thank
Karol.
you.
Thank you, Pak Dekan, Mbak Ibu, dan
Bye-bye.
ada
Thank you so
Profesor
much,
Mahmudul, Bu
Bu
Kanti. Bye-bye.
Dekan.
Izin live ya. Thank you.